Hello landlords, it's Ernie Garcia, landlord attorney, and today we're talking all about accessing your property. Let's get started. So we get a lot of people who come to us and say, I'm just having the hardest time with my tenant. Every time I want to go and make an inspection or do a repair, I get the runaround. If that's you, then you've got a lot to learn. I want you to stick around to the very end. I've got a lot of good advice for those of you who are having difficulty with a tenant denying you access or making access to your real property a real headache. The first thing you have to consider is what's in your lease. Do you have the right to access your property in your lease? You'd be surprised, but there are a few written agreements out there that don't even cover the landlord's right to access property. Does your lease give you the obligation to give some kind of notice to your tenant? Generally speaking, a lease will say something to the effect of, if there is some emergency, you don't need to give notice. But generally speaking, if you intend to access the property, you agree to attempt to give notice to your tenant. And I always recommend to landlords that you give notice, even if your lease doesn't require it, that you give some notice. I'm not saying you need to ask for permission. If your lease already grants you the right to access the property, whether you're making an inspection or a repair, or you're showing it to prospective tenants or prospective buyers, whatever it is that's going on, as long as you enter reasonably and stay there peaceably, the law protects your right, especially if it's adequately explained in your lease. If you don't know what your lease says about access, I strongly recommend that you read it. If you're using a lease that is silent as to your access to your rental property, you need to stop using that lease. You need to update your lease so that you have something in writing that's agreed to by your tenant that you at least have the right to access it. It's important, and we tend to recommend to landlords that you're upfront with your tenants about your intentions of inspecting the leasehold from time to time. My recommendation is at least twice a year, maybe at the 3rd month and the 6th month, to come in on a 12-month lease to come and see how things are going. So from time to time, I have clients who come to me and say, look, every time I send notice to my tenant, they tell me they can't be there at that time, so can I come at some other time? Or they say, look, please don't come when I'm not there. I want to be there at all times. You know, maybe your tenant has some trust issues, or maybe your tenant is genuinely interested in being there at the same time. The truth is you probably don't have to coordinate with your tenant. However, it might be a good customer service idea for you to do it. If it doesn't mean a whole lot, you know, whether it's on Tuesday or Thursday, but it means a lot to them, then maybe you should accommodate them, right? This is different than an absolute prohibition, an absolute ban. They say you're not coming in no matter what. If they want to be there and they're otherwise open to the inspection or to the repair, or to you coming in and showing off the property to another party, but they would like to be there, or they would prefer that you do it at a certain time, it doesn't hurt you to accommodate them, generally speaking. And so it's always good customer service, number one, to give notice, but it's also good customer service to work together with your tenant, if it's at all possible, to accomplish your goal and theirs. Landlords, I want to thank you for watching this video. I invite you, as always, to join us on Facebook and follow us on Instagram. If you are not yet a subscriber, go ahead and subscribe today. And if you enjoy the content, give us one of these. We appreciate you. Now, what if the tenant goes as far as changing the locks? Sometimes you don't have good communication with your tenant and you come up to the door fully intending to make a repair or conduct an inspection or have someone check out the property, and you find that your key no longer works. What does your lease say about changing locks? Now, generally speaking, a tenant cannot bar an owner or a landlord from entering the property. But what if, for example, mom and dad are out grocery shopping and they've left their minor children at home with a keyless deadbolt? Well, if you install that keyless deadbolt, you already know that, okay, The reason I can't get in is because there's a keyless deadbolt. But if they installed something and didn't give you a key, that's a different situation. And it may actually be a default in the lease. What I would recommend is that you send written notice to your tenant, letting them know that you attempted to access the property, but that you were denied access because they changed the lock. I would further recommend that your notice order them to change the lock back or to give you a key for the current lock. You cannot be denied access to your own property, especially if your lease specifically prohibits the tenant from changing locks and not giving you access. The key to establishing that you have done the right thing is to make sure you can prove, perhaps in some future eviction, that you gave adequate notice to the tenant demanding that they change the lock. If you have to do this over and over and over again, it could build a suitable case for you to demand possession from that tenant. Even if that tenant is a rent-paying tenant who pays their rent on time, this breach of the lease may amount to a sufficient cause for you to file an eviction. And each of these notices that you have over the weeks and months could be the way you build your case against them. If your tenant absolutely prohibits you from entering the lease, so the leasehold, you have the right to enter, but only if you can do it at a reasonable time and in a peaceable manner. So what does this mean? Well, let's say you show up and your tenant starts yelling and screaming and throwing plates. Is the time peaceable anymore? Is the entry reasonable anymore? It is not. And even if it is the tenant who causes the breakdown of the peace, you cannot enter. Now, what this also causes is a breach of your lease. And just like with the changing of a lock, a tenant who prohibits you in any manner from entering the premises is technically in violation. This is why sending notice is helpful. This is why coordinating with the tenant is helpful. But if a tenant becomes belligerent and uncooperative, then you have cause to send notice of default. And at that point, you can begin to build your case against this tenant in the event that you need to file an eviction. So this is different than a tenant who changed the locks. Perhaps they did it unknowingly. This is someone who is obstinate and not willing to cooperate with you, even though your lease may require that they do so. Because of this, you probably have the grounds to send multiple notices of default to the tenant. I would argue that once you've sent about 3 of those, it's time to send a notice to vacate and begin the eviction process. All in all, landlords, you have certain rights to enter the property and conduct inspections and make sure that things are being maintained. You have the right to come in even and take photographs and shoot video. You don't have the right to go beyond privacy. And so while you can enter the home, you can't really look too closely at personal things. But you have every right to go in and check the condition of the home. How are the walls doing? How's the AC doing inside and outside of the home? You know, is there a leak coming from upstairs? You know, how's the plumbing functioning? It helps you to go in there and find these things out before a problem occurs. If you can catch something early, that's always best, which is why the law is on your side if you are making an inspection. However, if you don't know this and you don't know how to access your property and enforce the provisions in your lease that allow you to do so, you may go 12 or more months and a problem that was small to begin with might turn into something much larger.